Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a very interesting book which has come to us from Edward Elgar Publishing Limited. They're an independent family firm of publishers producing very substantial works, generally speaking, at a high level in certainly both legal and business titles. This particular one is very much a modern book dealing and looking at the way in which our interface judicially with Europe is developing. And it's called Regulating Judicial Activity in Europe, and it's got a subtitle, A Guidebook to Working Practices of the Supreme Court. It's been edited by the network of the presidents of the Supreme Judicial Courts of the European Union, so there's no specific named person. It's a very small book. We'll have a look at it because you can see, even with the title, that it's looking at the way in which judges make decisions across Europe with a view to seeing what, if anything, by way of harmonisation. They use the word regulating, but it's basically looking to see where there will be a like mind, if you like, so that we are all basically singing from the same hymn sheet, if I can use, if I dare allowed to use that sort of expression. But the point is, that's really what it's about, looking at harmonisation. It says regulating, but that really is looking to see that there is a proper standard of orthodoxy, if you like, from doing it across the European board in terms of their Supreme Courts in any event. Now, my wife Elizabeth and I talked about the book because it was not one that we've really had that much thought about in the past, but we gave it the title belonging to a European judicial community examining the working processes of European Union Supreme Courts, because that's really what this book is about. Let me show you the book. It's a very small one. There we go, there's the front of it. There's that, and then there's the back. It's part of the Judicial Review and Cooperation series from Elgar. It doesn't run to very many pages, it's 140 odd pages. There's the index at the back. See, a reasonably short index. Then you've got the little statement about Judicial Review and Cooperation and what they're doing, and then that's the front page itself. Then that sets out where the actual funding came for it from. The two parts are structured there very clearly, you can see that. As I say, there are a number of contributions. Actually, that's in French, which assists us as well. Then there's a foreword, which sets out what the purpose of this book actually is about. And then after that, you've then got it again in French, and then you've got the preface. Again, the preface in French as well. So you can see, and then we go into the book itself. It starts off with protection of independence, and it runs through. It's quite a hard book in some respects to follow through, because you've obviously got it written both in French and in English. So unless you come from Canada, where you're perhaps a little bit more used to that bilingual approach, you will find that for the English version then there's a French version as well, and that runs through. So it's a very small book, so it's not something to take you very long to read through, but it's well worth looking at, and it's a very interesting area for the future. This is what we say anyway, from lawyers and academics to researchers and students of justice systems within the European Union. There will certainly be a wide range of readers interested in this new publication from Elgar. It's been referred to as a book for the 21st century, for it examines current and indeed anticipated trends in justice systems across the European Union. It represents a first for Elgar in that its publication marks the start of Elgar's new Judicial Review and Cooperation series, and that's, as I say, mentioned at the front. Writing in the foreword, Fabrizio Carfaggi, who's Professor of Comparative Law and Director for the Centre for Judicial Cooperation, that's the EUI, refers to Elgar's forward-looking initiative as, quote, an innovative project that links academics and judiciaries in a common endeavour to investigate and debate issues relating to the role of judiciaries in legal development and innovation. And there again you've got the idea, and that is that they're all basically coming from the same standpoint, and that really does give some stability, of course, to the judicial systems across Europe, of course, if you're looking at it that way. He also observes that the legal evolution, the kind that is happening across Europe, is not the task of a single institution, but the outcome of collaborative commitment of several institutions. Elgar's new series will therefore focus on the new forms of dialogue between courts, in this case Supreme Courts, dedicated ideally to protecting the rights of EU citizens and EU constitutional identities. As I've indicated, the book's divided into two parts. Part one covers the first aspects of independence of justice, and it focuses on issues relating to the independence of the judiciary. And the first chapter of the section, for example, is written by Klaus Tolksdorf, who's president of the Federal Court of Justice in Germany. The book's other contributors are similarly of a senior level. His dissertation centres on the various ways and means by which the independence of judges may be safeguarded, including constitutional and statutory safeguards. And part two deals with the budget of the Supreme Courts of the European Union. The writer here is Vincent Lamander, who's first president of the Cour de Cassation, France. As the EU is, in his words, undergoing a major economic crisis, reducing public expenditure must now be the watchword. His treatise ends on a rather positive note, however, as he sees the current economic difficulties as an opportunity to achieve greater efficiencies in expenditure, quote, improving judges' working tools and the judicial processes despite the credit squeeze. Let me conclude by saying this slender volume, and it's not a very big book because obviously part of it is in French, so you've probably got about, at the very most, about 60-70 pages. It's a slender volume. It does shine the light of scrutiny into the workings of Europe's supreme judicial courts, and as such is an encouraging example, we think, of the effort made by the European judiciary to maintain and carry out their roles as legal innovators, as well as conservators of the core principles underpinning the impartial dispensation of justice. It would appear that the overall aim here is the eventual harmonisation of Europe's judicial community. Now, I say that with a word of warning because obviously everybody will, in each member state, will very much keep their own territory, as it were. But what they're trying to do is to get some, I'm using the word harmonisation. I think regulation is a bit strong, but I think harmonisation is probably the best way of doing it. In other words, so there is a level. You've got a level all the way across, so that you know that you're going to get a good standard of justice, which is to be expected, in other words, the highest standard of justice, and at the same time, it won't be up and down depending on which country you go to. So if you have that, it's a much better way of trying to work out where rights are infringed and can be protected, if you look at it from that point of view. Finally, academics, researchers, and certainly international lawyers involved professionally in this area will find this book an insightful and fascinating read in our view, and the publication date is cited to 2014. I'll just run through it again very quickly with you. There's the front. It's actually in English, the front and the back, the spine and the back. But when you go into it, as I say, you've got the index in English there, and then you go the index in French. And what you've got is, again, you can see right at the end, it's all in French, but the earlier bit is in English. So it starts in English and then goes from English to French. That's the actual Judicial Review and Cooperation organisation structure of books that are to come. And as I say, it has been funded, as you can see there. And then you've got the structure of the book itself, both in French and English. I'd like to thank the authors and Elgar in particular for producing something that's really quite interesting as we develop judicial jurisdictions in the 21st century. The future for the EU, no one really knows at the moment. Obviously it's moving forward, but it's quite clear that something of this nature is very important, and it's something that is actually probably urgently needed, so that we've got a nice level playing field. We know where we are, and you know that you don't play one court off against another, because that is the danger. It isn't mentioned now. I'm probably stepping over dangerous ground here, but that is the danger that you might have. So thank you to all concerned for an excellent publication, and good luck with this new series of books which you're publishing at Elgar. Thank you to all. Bye bye.